first group of texts are selections from the earliest great human civilizations in Mesopotamia and Egypt. Ancient Mesopotamia and ancient Egypt, along with ancient India and ancient China, are considered the cradles of civilization in Africa and Eurasia. Other ancient cultures, including the Carol Supe in Peru and the Olmec in Mexico, are considered cradles of civilization in the Americas. You may remember from a high school or a college world history class that Mesopotamia means between the river. Mesos in Greek is middle and potamos is a river. The rivers in question are the Tigris and Euphrates, running through modern Turkey, Iraq, Syria, Iran, and Kuwait, from the Zagros Mountains to the Persian Gulf. This area is also called the Fertile Crescent. The river's cyclical flooding produces rich soil. Settled agricultural practices first originated in this area about 11,000 years ago. The first city-states, including Ur, Uruk, Nineveh, Akkad, and others, began to form here about 5,000 years ago, followed by the first forms of writing and the first written legal texts. You may also remember that ancient Egypt flourished along the Nile River in northern Africa through areas today encompassed by modern Egypt. Like the Fertile Crescent, this region was agriculturally fruitful because the annual river floods deposit fresh, fertile soil. The dynasties and kingdoms we call ancient Egypt began about 5,000 years ago. When we look at these ancient Mesopotamian and Egyptian texts, then, we're reaching all the way back into recorded human history. And, as we'll see when we look at the Hebrew Scriptures, what Christians sometimes call the Old Testament, this historical context had an enormous impact on the foundational texts of Judaism and Christianity. There are interesting differences between Mesopotamian and Egyptian legal texts. The primary difference being that the Mesopotamian sources are filled with legal materials, while what we would today call law is scarce in the Egyptian sources. Some of these apparent differences might result from the kinds of texts that have survived. In Mesopotamia, records were kept on clay tablets that have survived in significant numbers over the millennia. In Egypt, papyrus made from the papyrus plant was a common writing material which degrades easily over time. More durable writings on stone tomb walls or public monuments typically did not include routine legal texts, and other durable writing materials such as ostraca, pottery sherds, are also fragile. It could also be the case, however, that the Mesopotamian traditions reflect a more robust and flexible commercial and legal culture, and that ancient Egypt was more rigidly hierarchical. Even in the Mesopotamian sources, it's important to remember that we have access only to a small slice of daily life. Many of the sources, particularly the law codes, present an idealized elite perspective that rarely would have applied simply and directly in ordinary circumstances. Trial records and other texts show that most law on the ground derived from custom and practice, and the broader sources in the form of codes and decrees were interpreted in various ways in different cases. In fact, one lesson we can learn from these ancient law codes and decrees is that published legal texts, etched literally in clay or stone, have always existed in a fluid relationship with the people, institutions, and informal norms through which they are interpreted and applied. The Enuma Elish is also called the Seven Tablets of Creation. It's a Babylonian tale dating to before the reign of Hammurabi that describes the creation of the heavens, the earth, and humanity. One thing I want us to notice in this class is how our understanding of human nature is always tied to an origin story, and how the origin story of humanity is always tied to our understanding of law and society. This is true even in modernity and even for secular thinkers who believe the only and complete explanation for human nature resides in our evolutionary past. The Enuma Elish is not the only text relating to ancient Near Eastern stories of creation, but it seems to contain some recurring themes, some of which, as we'll see, might even be echoed in the Hebrew Bible. In the Enuma Elish, the old gods Tiamat and Apsu decide to mate and create lower gods. Apsu, however, is annoyed by the commotion caused by the lower gods and plots with Tiamat to destroy them. The lower gods fight back. Apsu is killed, infuriating Tiamat. Marduk and Tiamat then engage in an epic showdown. Marduk prevails, killing Tiamat, and splits her body in two. One part of Tiamat's body becomes the heavens and the other the earth. The other lower gods are installed in the heavens to govern the seasons and days. As the victorious gods celebrate, Marduk decides it would be good to create humans to bear the burden of the gods' work and so that the gods may rest. The god Kingu is accused of having stirred up Tiamat's anger, so Kingu is executed and his spilled blood results in the creation of humans. The gods then construct Babylon to house and honor Marduk. Marduk is thus established as the principal god over the heavens and earth, ruling from his capital, Babylon. Human sinners and evildoers are accountable to Marduk, and people receive instruction from him. The Laws of Ur-Namma. This is the prologue and a portion of a law code likely originating with Ur-Namma, king of the city of Ur. It dates to about 2100 BCE, that is, about 4,100 years ago, making it the oldest extant written law code. Ur-Namma gained independence for Ur from the leadership of the city of Uruk, and founded what is today known as the Third Dynasty of Ur, a time of economic and cultural flourishing. Notice how the preface is a narrative that describes the gods' activity regarding the city along with Ur-Namma's mighty deeds with the help of the gods. In addition to stabilizing trade and security around the city, Ur-Namma says that,
I did not deliver the orphan to the rich. I did not deliver the widow to the mighty. I did not deliver the man with but 1 shekel to the man with 1 mina. I did not deliver the man with but 1 sheep to the man with 1 ox. I eliminated enmity, violence, and cries for justice. I established justice in the land.
It's extraordinary that the concept of protecting orphans, widows, and the poor appears in this earliest legal source. We'll see that these priorities are also prominent in the Torah, the Jewish law, and the Hebrew scriptures, as well as in the New Testament and in Islamic sources. The first paragraph of Ur-Namma's code recites the death penalty for murder. For fellow etymological nerds, the word translated murder, sagish, is a compound of to strike, head, and wooden tool. This demonstrates that human life was highly valued and protected by law from the earliest times. Ur-Namma's code also shows, however, that the ancient Near East was by no means an egalitarian society. Many of the laws reflect the reality of slavery and the lesser social value of slaves. You should note, however, that the term we translate as slave from Sumerian, Akkadian, and Babylonian sources can have a broader valence than the modern terminology. As scholar Seth Richardson notes in his chapter on Mesopotamian slavery in the Palgrave Handbook of Global Slavery Throughout History, in these cultures, slavery was primarily a mechanism to provide credit in an emerging mercantile economy, which otherwise had few, if any, stable financial institutions, rather than to satisfy labor needs in any other productive sector. According to Richardson, the entry to and exit from slavery were relatively asystematic. The status often ended up being temporary, and the functions and status of slaves are difficult to distinguish from those of other persons, e.g. servants and dependents, who also performed labor under coercion. In many cases, then, slaves might have been more like bonded laborers than chattel slaves. Nevertheless, as Richardson also notes, these early social arrangements and laws certainly normalized a status of slavery within what would later become the Western legal tradition. Ur-Namma's code also demonstrates that women did not enjoy the same status as men. Paragraphs 6 to 7, for example, assume that a young man has some kind of legal claim over his spouse and that the woman has no legal agency over her sexual life. At the same time, some of the laws protect vulnerable women. For example, paragraphs 9 to 10 require a man to pay a divorce settlement if he dissolves a marriage. Other laws in this code establish a kind of strict liability fixed damages tort system. 10 shekels for a foot, 60 shekels for a broken bone, 40 shekels for a nose, 2 shekels for a tooth in paragraphs 18 to 22. These provisions remind me of conversations with a friend who is a personal injury lawyer. In most cases, he knows just what the insurer will pay for a certain kind of injury. This demonstrates that compensation for injury and property damage has always been a concern of the law. Finally, yet other laws relate to civil procedure and evidence, paragraphs 13 to 14 and 28 to 29. The river ordeal, referred to in paragraphs 13 to 14, was common in Mesopotamian legal culture. It involved the accused, a witness, or some proxy representative walking or swimming some distance in a river, usually carrying a weight or other encumbrance. If the person completed the test and survived the ordeal, they were deemed innocent or credible. If not, they were guilty or discredited and perhaps drowned. It was assumed that the appropriate gods oversaw the outcome of the ordeal and ensured justice was done. Of course, the prospect of an ordeal might also have served as a practical deterrent to the assertion of frivolous claims or defenses, as well as a powerful lever for securing confessions, whether the accused was guilty or not. Trial by ordeal became a widespread practice across cultures and would remain viable into the modern period. This is reflected in the trial report that is part of our reading. While to us the practice lacks a rational basis, it shows the close connection in the ancient mind between law, justice, and the knowledge and decisions of the gods. At the same time, paragraphs 28 to 29 of Ur-Namma's code reflect a broader concern for truth-telling by witnesses, including the practice of taking oaths to secure truthful testimony and penalties for perjury. The Laws of Hammurabi. The Laws of Hammurabi are a law code written during the reign of Hammurabi, ruler of Babylon from 1792 to 1750 BCE. It's the longest extant code from Mesopotamia and is famous because of the dramatic black basalt stele on which the laws are inscribed, now housed in the Louvre in Paris. Notice that, like Ur-Namma's code, the Laws of Hammurabi open with a narrative describing the king's relationship to the gods and his mighty deeds. Like Ur-Namma, Hammurabi claims that he has been commissioned
to make justice prevail in the land, to abolish the wicked and evil, to prevent the strong from oppressing the weak.
The preamble recites Hammurabi's titles, piety, and virtues at great length, an imposing bit of propaganda, particularly when beaming forth from a public source like the over 7-foot-tall stele in the Louvre. There's a replica of the stele in the United Nations headquarters in New York, and Hammurabi is one of the lawgivers on a relief that adorns the U.S. Capitol building. The epilogue to the laws restates Hammurabi's connection to the gods and virtues at great length. Hammurabi proclaims that,
in order that the mighty not wrong the weak, to provide just ways for the waif and the widow, I have inscribed my precious pronouncements upon my stele and set it up before the statue of me, the King of Justice.
It concludes with invocations of various gods and goddesses within the Babylonian pantheon, the great gods of heaven and earth, all the Anunnaki deities together, demonstrating that all the powers of the heavens are behind Hammurabi's laws. There are similarities in subject matter and form between Hammurabi's laws and those of Ur-Namma, but you can readily see that Hammurabi's laws are more complete and extensive, not least in placing a burden of proof, often on pain of death or on pain of the river ordeal, on an accuser. In fact, the first provision of Hammurabi's code is not imposing the death penalty for murder, but rather imposes the death penalty for a false accusation of murder. That murder itself carries the death penalty seems to be assumed, which is why a false accusation is so serious. Hammurabi's code also shows a concern for the function and institution of judging and for precedent and the finality of judgments. Paragraph 5, for example, requires a judge to pay damages and surrender his judgeship if he reverses a settled judgment. Today we protect similar values in civil litigation through procedural rules that make it exceedingly difficult to reopen final judgments, including principles of res judicata. and in criminal law through the double jeopardy doctrine. Hammurabi's code is often given as an early example of the lex talionis, an eye for an eye, a tooth for a tooth. This is precisely the rule, for example, in paragraphs 196 and 200. The term awilu refers to a free upper-class person. You can see in paragraphs 197 to 198, 201, and elsewhere that the lex talionis only applied directly across the awilu class. People of lower classes were worth less. The Hittite Laws. The Hittite Empire, also called Hatti, was established in the northern Anatolian Peninsula from about 1650 to 1180 BCE. Like the Assyrians, Akkadians, and Babylonians, the Hittites wrote in a cuneiform script. Their culture was contemporaneous with the Semitic cultures that gave rise to the Hebrew Bible, and they are in fact mentioned in the Hebrew Bible. But their language was Indo-European in origin rather than Semitic. This is interesting because two of the other great sources of ancient thought about law we'll encounter in this unit, ancient Hindu and ancient Greek, are also embodied in texts composed in Indo-European language families, Sanskrit and ancient Greek. You'll see that the sparse collection of extant Hittite laws is similar in tone and content to the Mesopotamian sources. It seems then, at least from the available limited evidence, that the Hittite legal culture more closely resembled Semitic sources, Assyrian, Akkadian, Babylonian, and Hebrew, than sources from cultures that shared an Indo-European linguistic heritage. When we look at the ancient Hindu sources later in this unit, you may notice some resemblances both to the Semitic and Greek sources, a kind of crossover between the codes and social structures of the Semitic literature, and the emphasis on personal virtue in the Greek sources. We don't know for sure how the legal cultures of all these ancient societies intermixed, but we do know from archaeological and documentary evidence that there was plenty of interaction concerning religion, literature, and trade, both in times of peace as well as through conflict and war. Egypt. As mentioned, we have relatively few extant legal materials from ancient Egypt. Our reading is from the Book of the Dead, also called the Book of Going Forth by Day. It's a collection of knowledge and spells that would enable the deceased to navigate the afterlife. The text is not systematic, and it's not always clear how all the spells fit together or how the Book of the Dead might have related to ancient Egyptian religion at the popular level. One of the most evocative portions is the deceased's declaration of innocence before the divine council and the weighing of the heart by Anubis before Osiris. Notice the list of sins about which the deceased must profess innocence. Framed in negative terms, they could be equated with moral and legal commands, as we will see in the Ten Commandments in the Hebrew Scriptures. In positive terms, they could be associated with virtues, such as honesty and fidelity. The deceased's heart is placed on a scale, balanced by a feather from the god Ma'at, the goddess of truth and justice. If the scale balances, the deceased can pass into the fields of Laru, a kind of paradise. If the heart is heavier than the feather, the deceased is devoured by the monster Amit, the devourer of the dead, part hippo, part lion, part crocodile.